Hi guys, ready for the new case law? So, as promised in my previous video, that I will tell you about some relief of doctrine of constructive notice. This case law is based on Doctrine of Indoor Management. Now let me explain you what is Doctrine of Indoor Management. I hope you know about the doctrine of constructive notice, and those who don't know, please watch the video first, otherwise it would be difficult for you to understand. So, the hardship caused to the outsiders dealing with a company by the rule of constructive notice have been sought to be softened under the principle of indoor management. It affords some protection to the outsiders against the company. According to this doctrine, after satisfying themselves that the proposed transaction is in articles, person dealing with to inquire whether the internal proceedings were correctly followed. They are entitled to assume that the internal proceedings relating to contract are regular as per the memorandum and articles. They are entitled to take it for granted that the company had done through all these proceedings in a regular manner. So this is known as Doctrine of Indoor Management.
Hello, sir.
Hi, William. So, the bonds paper are ready?
Yes, sir. Just coming. Getting the signature.
Okay, all right, all the necessary works have been done? I have seen your memorandum and articles. It says that the directors have the power to borrow money. Am I right?
Yes, sir. You are absolutely right.
The company had given a bond for £2,000 to the Royal British Bank, which secured the company's drawings on its current account. The bond was under the company's seal, signed by 2 directors and a secretary. Later the company, Cameron's Coalbrook Steam, Coal in Swansea and Lower Railway Company, went into liquidation, and Mr. Turquand was appointed as a liquidator.
Hello, Mr. Turquand. Hello. Thank you for coming, sir. Let's sit. Sir, you are appointed as the liquidator of the company. Yes, I do. Sir, I heard that. You are paying off the liability, but sir, the British Royal Bank bonds are not been paid off. Yes, I know, because your bond was not properly issued as there were no proper authority of the directors, and thus it is invalid. Sir, but I have the document signed by the directors. But the money can be borrowed through resolution, and those were not passed, thus permission from the shareholders were not taken. Sir, this is not fair. I will sue you.
And thus the bank sued the liquidator.
Sir, I am the representative of Royal British Bank. Our bank had taken a bond for £2,000 from the company with proper common seal and signature of the directors and the secretary. And now they are refusing us to pay back. Sir, but the directors only had power to borrow up to an amount authorized by a company resolution. Sir, but a resolution had been passed, although not specifying how much the directors could borrow. But sir, how can we as an outsider to a company know what is happening inside the company? I have taken my necessary steps of checking the authority and signatures.
Since the deed of settlement registered under the Joint Stock Companies Act, 1844, allowed the directors to borrow on bonds such bonds from time to time through a resolution passed at a general meeting of the company. The evidence showed that such a resolution had indeed been passed, but the amount of money which the directors were authorized to borrow was never defined. The dealings with companies were not dealings with ordinary partnerships, and though the public should have known the contents of the documents that are public, and any party reading the deed in instant matter would find that there was no prohibition from borrowing stated in the deed. Thus, any such party was entitled to assume that all internal procedural conditions not mentioned in the deed had been followed. and thus the bond is valid. So the Royal British Bank could enforce the terms.
Hi guys! So, you're looking happy, isn't it? But this advantage has some exceptions. So, before you're overexcited about the same, you should be careful that you don't fall under these conditions. So, here are some exceptions. First, where the outsider has knowledge about the irregularity and he still enters to the transaction, he cannot seek protection of the indoor management. Second, no knowledge of MOA and AOA. I told you, you should know the MOA and AOA of the company before transacting with it, and warned you about this in my videos also. Third, forgery. Forgery means fraud, and if there is a fraud, the transactions are void, and thus you cannot seek protection under indoor management. Fourth, negligence. The doctrine will never protect you if you are careless or negligent. Thus, be safe and careful. Bye. See you again. Keep sharing and please write the comments so that I know whether you are liking the videos or not.